So first of all, I want to thank everybody for coming tonight. We're really, really excited to have you. We're really excited to have Paul Cienfuegos here. I heard Paul a few weeks ago, it was a few months ago, I guess it was, in the library. And I was so impressed. I was not expecting to hear what I heard and to learn as much as I learned, because I thought I knew a lot, but I learned a lot from Paul that night. And what I was also most impressed about is the way he was uniting everyone together and the importance of it, and talking about how many different people from different walks of life and different political persuasions were participating in their community rights program. So that's what really impressed me, and it got me thinking about what we could do if we left all of our divisions and all of our labels behind. And we just focused on one thing, really, was the people of Fairfield and what the kind of life that we want. And looking at the issues as they come up rather than the things that divide us. And if we do that, I have no doubt that we can completely transform our community and actually set an example for communities all across the country. And Paul has the knowledge that we need to be able to do this. So we had a dialogue, and he said that he would come back. And I kind of look at this, and all of us involved, we had some great meetings today and in the last week with diverse groups in the community, and we're making tremendous progress. And I really think this could be a watershed event. So anyway, I was really happy when Paul agreed to come back here. Thank you for coming. Paul basically is extremely knowledgeable about the founding principles of our country and how we can apply those founding principles to take back control of our local communities and our own individual sovereignty as well. So, leading activist in the community rights movement in this country, please give a warm welcome to Paul Cienfuegos. Oh, excuse me. Just a minute. Hold that applause. We'll be able to do that again. First, before Paul gets up, we're going to have a few words from our sponsor tonight, who owns this facility and has been working with us on this project. Ed basically has a few things to say to you that I think you'll really like to hear. So, Ed Noyes. Sorry.
Thank you for remembering me, Clyde.
You're hard to forget, too.
So, welcome to an exciting evening of political enlightenment. Thank you for coming and being part of a new political revolution that embraces our divine right to control our political destiny. It's not difficult to see the intensity of the political discourse that is occurring in this country. Regardless of how we characterize our individual affiliations, whether Democratic, Progressive, Republican, Libertarian, etc., our higher selves seek for common ground. We long for a system that is grounded in genuine spirituality, harmony, consensus, and love. We also know that at this point in history, we are on the cusp of unlimited opportunity as evolution is speeding up. So how do we get there politically? What if the wisdom we seek has already been offered to us? Remember the words of Jesus, and he said, "Ask and you shall find. Ask and you shall receive. Seek and you shall find." What if that was true today? What if what we sought was available to us? What if it was true that what Maharishi said is whatever we put our attention on grows? What if we applied this truth for the betterment of our community? Thomas Jefferson said once that information is the currency of democracy. That is very good news, because we live in an information age. We are billionaires when it comes to information. But the problem is, how do we get that information to work for us locally? We just need to adopt a system. We need to create a new system locally that allows that information to be integrated into our community? What if it was true that tremendously successful policies and practices already exist in communities throughout America and the world? What if certain communities have already figured out how to transform their school lunch program, or to cause their children to gain 3 to 4 years in reading ability in a matter of months? What if that's just a very tiny sampling of what's already out there? The problem is that even though we have good-hearted people that we've elected, we're acting on an assumption that they're all-knowing. Not only are they all-knowing, but they're able to keep up to date with the rapid evolution of change that's occurring. And that's just simply not something that we can count on. So what if we adopted a system that complemented our current system and used the resources of our community and the people of our community to adopt a new system? Wayne Dyer spoke of the power of intention. He recently passed. And many other great thinkers, Napoleon Hill, for example, spoke of the power of intention. That Maharishi said, whatever you put your intention on grows. What if we put our individual and collective intention on the various elements that we want to create in our community so that Fairfield could become a world-class community on every level? Napoleon Hill also talked of the power of the mastermind. And I believe that the mastermind may be the most powerful technology on earth. And the reason being is, and Jesus spoke of this, when he said, whenever 2 or more are gathered in my name, I am there. He was talking about the divine consciousness. So if we come together in a form of a community mastermind, we can tap into the divine intelligence that is within us, and we can have outcomes that go way beyond what we could ever do individually. And that is what's being proposed here. What if many of the changes that we long for don't even require permission from anyone? What if most of what we want to do in this community we could do without even asking permission? We just haven't organized to do it. What if every one of us had a dharma and something inside of us where we all wanted to serve and we wanted to leave a legacy? What if we created a system that brought out the dharma of everyone and that allowed us to come together and research these opportunities and come up with these world-class solutions that, again, already exist? What if we then created a way that we could public source that information so that government is not done behind closed doors, but it's done open source? And we bring the light of day into government instead of letting the darkness rule. We already know that if you bring in the light, that the darkness will have to leave. So this is a process that we can have to bring in the light. Again, what if Fairfield could become a world-class community on every level? And what if the political messiah we have been searching for is us? The proposal is that we participate in a community mastermind process where everyone is invited to be of service to others without pay of any kind in the original model of the Founding Fathers, to discover those best practices already being adopted throughout America and the world, as well as to discover even more successful practices. You will be given an opportunity tonight to provide your contact information as well as your area of interest so that you may participate in this endeavor. Thank you for who you are and your innate desire to create a true world-class community for ourselves and for the generations to come. Thank you.
So thank you, Ed, and that was just giving you a vision of the kind of things that we're talking about here in these smaller group meetings that we've had. And now, please give a round of applause to our speaker, Paul Cienfuegos. Thank you.
Is this thing working if I'm this far away from it? How's the sound? It's good in the back? Great. All right. Let me just do a sound check or a time check for myself before I even start. Okay. So yes, thank you. Thank you to the various parts of your community who have worked so hard to bring me here for the third time since I was here in October. I was here in November, and I'm here again. And Clyde and I and others have been talking about me coming back in June for an interesting series of conversations where we think about what is governance and what does it mean for us to govern ourselves. So that conversation may be coming in the near future. So keep your ears open. But tonight, what I'm going to do is much more of a conventional, my kind of conventional 3-hour introductory community rights workshop, which is kind of back and forth between me giving some short presentations and being in conversation with all of you. And so the basic outline of the evening is that I'm going to talk for about half an hour or so. And I'm totally game to have you interrupt me during that half hour if you have...
Excuse me, Bruce, could you fix those lights so they're not in our eyes? Oh, sure. Thank you, appreciate it.
Good point.
Sorry, Paul.
Can you fix them so they're not in my eyes, too?
Yeah. Everybody go outside.
So yeah, I'm going to do kind of a 30-minute intro to the community rights movement that's going to fold in some history in how large corporations came to be so powerful in the United States. People have a basic understanding of how they're powerful economically and how they use their money to wield political power, but most people don't have a clear sense of how corporations are powerful through their rights, through their actual constitutional rights. Their legal power is the one that most Americans don't really understand. So I'm going to give you some insights into corporate power that comes through law. And that's really the most significant corporate power that we have to confront. So during my presentation, which hopefully won't last more than about half an hour as the initial part of the evening, you are more than welcome to raise your hand and ask a question while I'm speaking. But I'm going to ask that you keep the questions to clarifying questions around the point in the description where I am at that moment. Okay? So don't raise your hand in this first half hour and say, so what are we going to do about all this horrible news or something? So we have plenty of time for that. Okay? But if you want to be in conversation with me in my presentation, feel free, but try to stay focused on where I am at that moment. So, and then after I'm done, we'll have a more open conversation together. And at some point, after about an hour and a half or so, we're going to take a 10 or 15 minute break, and I'm going to encourage you to look at the timeline that I posted out in the hall, in the main room over there, of the rise of corporate constitutional rights over 200 years. There's an amazing 12-foot long printed timeline on a wall that I've set up. And I also am going to encourage you to look at some of the books at the mid-evening break, and to really consider taking them home and educating yourself about this stuff, because it is so critical that people have a deeper understanding of why corporations are so powerful and what local communities can do to get their community rights back. And then after the break, we're going to continue the conversation. I may do another brief presentation or two, but the primary purpose for the second half of the evening is that we're going to look to some degree in depth at an actual community rights ordinance that was passed in a small community in New Hampshire a number of years ago. I'm going to hand you a 4-page law ordinance. And actually, I might as well just hand them out now, because I know some people are leaving 45 or 60 minutes from now. And so you might as well just all have them before anyone has to leave. There's 2 different handouts, so if everybody can get both things, that would be cool. And this is always a little dangerous because, as any teachers in the room know, as soon as you hand out something, everyone looks at that instead of what the teacher's saying. So I'm going to ask you to be good and just put it down. Put them both down for now. But I want to make sure that before anyone leaves, you all get one. So So by the end of the evening, hopefully, you're going to have a lot more understanding about why large corporations are so darn powerful in the United States under law with constitutional rights. And you're going to have an introduction to an extraordinary social movement that has been building for 16 years in the United States that we call the community rights movement. Iowa, it's a movement of so far 200 communities in 9 states that have reclaimed their self-governing authority, regardless of what the state preemption claims, regardless of what corporate rights, corporate powers claim. They're taking back their authority to protect their health and welfare from harms that are coming in from outside, such as the proposed Bakken pipeline, such as giant factory farms, such as water bottling by corporations, putting your local public groundwater into little bottles and selling it around the planet for corporate profit, such as the dumping of urban sewage sludge on rural farmland, which has been happening all over the country for years, which is not a good idea. And a whole variety of other topics. Communities already in the United States in the last 16 years have passed these extraordinary community rights laws. And so I'll talk about them also in this story. So I'm going to launch. I'm going to get a little water before I get too far into this. I'm just going to tell you how this thing started, how the community rights movement started. It started in 1999 in a little, quite conservative farming community, family farming community, Wells Township, Pennsylvania. Population 520 people. Wells Township, Pennsylvania. And I'm going to back up before 1999. 1999 is when the community rights movement started to take off. But I'm going to back up the story and start in 1996, when the townsfolk in Wells Township, which was already a family farming community, that was their main income, and it was mostly family hog farms, small-scale hog farms. That was the main income in Wells Township in 1996. And they heard that year that they were going to be the recipients of a 15,000 head factory farm of hogs. 15,000. And they weren't real excited about that. When they pictured what it might happen to them if they had 15,000 hogs in giant warehouses across the landscape in their township, they thought about the stench, and they thought about the collapse of the property values of the farmers, and they thought about the human health impacts on their kids. And they just thought about quality of life in general, not to mention the way that the animals are treated. The inhumane way that the animals are treated. So they went to their township supervisors in 1996, and they said, it seems to us that there's virtually overwhelming opposition in Wells Township from the farm community to this proposed hog farm, factory hog farm. And we don't know where to go in Pennsylvania government. We're not very tuned in. What do we do to make sure that it doesn't come here? And their township supervisor said, well, we can only guess that you go to the Pennsylvania Department of Agriculture. And so a couple of carloads made an appointment, of these farmers made an appointment with the assistant director of the Pennsylvania Department of Agriculture in Harrisburg, the capital. And off they went, and shortly thereafter, they had a meeting with the guy, and he welcomed them into his office, and he said, glad to see you guys from Wells Township. We have, and as you know, we have an application that we're processing for this 15,000 head factory farm of hogs. And we're currently working up a manure management plan for the application. And we'd love your input on our manure management plan. And the farmer said, we're not really interested in talking with you about a manure management plan. We're here to say we don't want the factory farm, and you just need to decline to allow it to be given a permit. And the assistant director of the Pennsylvania Department of Agriculture said, well, that's really not my job. My job is to look at the applications that come in through the regulatory process from large corporations, mostly from large corporations. And as long as the permit meets the standards of our state law, as long as all of the, if there was an environmental study or a health study or whatever is required for the permit to be approved, as long as the permit is what is called administratively complete, we tend to approve the permit. That's how the regulatory system works, right? You wouldn't regulate something that you're prohibiting in a government agency. It's called a regulatory agency because it regulates permitted corporate activities, activities that have permits that legalize the activity in a community. Well, the farmers were pretty stunned by this because they had grown up as good patriotic Americans, and they understood from their early childhood classes that we the people are the sovereign people, that we have self-governing authority, that our state and federal constitutions have very flowery language about government serving us, being responsible to us, etc. And here, just to remind you of your state constitutional language, here's how your state constitution in Iowa starts. All political power is inherent in the people. Government is instituted for the protection, security, and benefit of the people. It's very clear. And they have the right, the people have the right, at all times, to alter or reform the same, the government, whenever the public good may require it. This is the opening paragraph of your state constitution, and most state constitutions have similar language. The people have the right, at all times, to alter or reform the government, whenever the public good may require it. It's very clear. It's one of the last remnants of the revolutionary fervor from the American Revolution. Most of the actual original language from the Revolutionary era has been stripped from state and federal constitutions. This is one of the last pieces that's still there in every state. I guess the power holders who weren't comfortable with that early revolutionary language probably, I'm just guessing, that they felt it was a little too obvious to take out that last couple of phrases, that the people were not going to be happy with that. But there used to be a lot more. So the farmers were really stunned by this, that they couldn't just say no to the regulatory agency. That's not the way the system worked. And so they went back to Wells Township in 1996, pretty pissed off, and they hired a public interest law firm called the Community Environmental Legal Defense Fund. It's kind of a mouthful. If you're taking notes, just write down their acronym, which is their website. It's a really cool website, which is CELDF, CELDF.org. And that stands for Community Environmental Legal Defense Fund. It's a public interest law firm in Pennsylvania. And CELDF, that's the awkward sound of those 5 letters together. CELDF had for years been an award-winning public interest law firm helping communities battle regulatory approvals. And they had a pretty sterling record. They were able to get regulatory directors on a regular basis to decline these corporate proposals. And yet they were realizing after years and years of doing this that if they went to the communities where they had helped a community to get a regulatory application denied, that ultimately those applications were all approved sooner or later, because as soon as the application was administratively complete, they were approved. And so they realized after years and years of doing this that all they were doing, really, was helping, they were giving free labor to the corporate attorneys to help them fill out their application completely and accurately so that the application would be approved. And that was pretty depressing for them to realize. But they'd been doing that for this group and others for many years. And one day, and they helped the Wells Township farmers to block this thing for a couple of years through finding faults in the application. And one day, the farmers said to the Seldiff attorneys, we don't understand why we can't stop. Why don't we have the legal right in Wells Township? We have a township government that we've elected, right? We pass laws here. Why can't we pass a law in Wells Township that says factory farms are prohibited in our township? We don't understand that. You know, we understand the language in our state constitution. It should be really clear that we have that power. And the Seldiff attorney said, well, there are a whole variety of what we call structures of law that are hidden in plain sight in the United States that most people have never really thought about, including most political activists. Most political activists don't even know about these structures of law. And I'll name them and give you a brief description of each one. And the farmers were really stunned when they heard this story. The first one that I'm going to tell you about is called state preemption. State preemption, how many people have heard of state preemption in the room? A lot of people. In a nutshell, state preemption says that if the state regulates or legalizes, right? To regulate is to legalize or to allow. You wouldn't regulate if you're going to prohibit the activity. If the state regulates a certain corporate activity, factory, farm, pipeline, whatever, the local government is prohibited from banning that corporate activity. The state preempts the local from banning what the state considers lawful corporate activity, right? It's going to regulate it at the state level, so you can't ban it at the local. State preemption. The second one is called Dillon's Rule, and it's kind of the flip side of state preemption. And Dillon's Rule is named after a state Supreme Court judge from Iowa in the late 1800s, and that's Dillon with two L's, Dillon, and his full name is John Forrest Dillon. You can look him up on Wikipedia and other places. There's some interesting stuff about him online. And it's Forrest with two R's, John Forrest Dillon. John Forrest Dillon was a late 1800s state Supreme Court judge in Iowa. And in the 1880s, he came up with an idea. And I guess judges, when they come up with ideas, they can turn them into their rulings, and they can have enormous political power because they're the elite, they're judges. If I had an idea, it wouldn't go much of anywhere at this point in terms of the law, but he's a judge. So I shouldn't underestimate myself. That's kind of a strange thing for me to say. Because we actually are changing these things. So you can scratch the last sentence I said. John Forrest Dillon's idea was that that the proper relationship between state government and local government is that of parent to child. And we all know who has the authority, the real authority, in a parent-child relationship. That the child, the local government, in John Forrest Dillon's eyes, has only the power that is granted to it by state government. That it has no inherent authority on its own. That the local government only exists because the state government lets it exist. It doesn't stand alone from state government. It is a creation of state government. That state government, with a stroke of the pen, can dissolve local government. And in Michigan has been recently, as you might be noting. The Michigan governor over the last few years, in Flint, Michigan, and other places, has either dissolved the city council or taken all its power away and replaced it with an executive manager that he appoints, who has all the power at the local level. So that's Dillon's rule. That there's a quote from John Forrest Dillon, the local government is a mere tenant of the state, right? And we all know about how much power tenants have in relation to landlords. So Dillon's rule, in this, how it grounds in reality here, is that under Dillon's rule, the local government only has the authority to make laws in the areas that the state lets it. So they can't make laws about anything they want to make laws about, only the authority granted by the state. That's Dillon's rule. So it's really a very kind of powerful trap that captures virtually all local authority, these two sides of the same coin, right? State preemption, you can't prohibit at the local level what the state regulates, i.e. allows. Dillon's rule, you can only make laws that we let you make, right? We will give you authority to make certain kinds of laws, and that's it. You don't have any inherent authority as a standalone local government. Now, it wasn't always like this. It turns out that, and our movement is digging up some fascinating research, that if you go back to the original constitutions from the states after the American Revolution, you'll find in state after state explicit language. Actually, let me read you. Let me just read you a paragraph from the original state constitution in Pennsylvania. Whereas all government ought to be instituted. Is this the right paragraph? It's not what I want to read. It's the next paragraph. That government is or ought to be instituted for the common benefit, protection, and security of the people, nation, or community, and not for the particular emolument or advantage of any single man, family, or set of men, who are only part of that community, and that the community hath an indubitable, unalienable, and indefeasible right to reform, alter, or abolish government in such manner as shall be by that community judged most conducive to the common good, unquote. That's from the original Pennsylvania state constitution. And this essay goes on to say, I'll just read one more paragraph, if people are the source of all governmental power, then governments must exercise that power for the common benefit of people. And to ensure that this happens, the community has an indubitable, unalienable, indefeasible right to reform, alter, or abolish government. That's heady stuff. It's not the state that holds the right, nor elected officials or government bodies, nor corporate interests. Rather, communities of people have an inalienable right to self-government, and they are powerless only in their inability to give that right away. It's powerful words. Well, clearly we're not in that situation anymore. But that's our history. This is not a crazy idea that local government should have its own inherent self-governing authority, that the people should have through their government that self-governing authority. So that's the second structure of law that most people don't even know exists. And by the way, around Dillon's rule, the U.S. Supreme Court adopted Dillon's rule in the first decade of the 20th century and started using it in the U.S. Supreme Court's decisions in the first decade of the 1900s. The third structure of law is called corporate constitutional rights. So these first two are about state power over local. This third one is about the U.S. Supreme Court over local and over state. It turns out that for 197 years, the U.S. Supreme Court has been granting one new right to the corporate business structure, to the actual corporation, not to its stockholders or its directors, but to the corporation itself. Are people familiar with the term legal fiction? Have you heard that term? So a corporation is considered a legal fiction, which basically means it exists under law, but it's a fiction in reality. In other words, if I asked you to take a picture of Dakota Access Corporation, which is the company that is proposing to build the Bakken Pipeline through Iowa. If I asked you to take a picture of Dakota Access Corporation, you actually could not do that. Does that make sense? All it is a business structure, right? You could take a picture of its directors, its headquarters, its pipes, right? Its physical manifestation of what the it does, right? That exists in the material world, but it's a legal fiction. It doesn't exist in reality as an it, right? So let's compare. So let's talk about corporate constitutional rights, because they are absolutely overwhelming and all-encompassing, and that's what that 12-foot timeline is in the other room that I'm going to encourage you to look at break. Starting in 1819. 197 years ago, amazingly, For the very first time, the U.S. Supreme Court got involved and did what some people would call judge-made law. In other words, they didn't just interpret law, they actually created law, which, as you know, in separation of powers, the judiciary is not supposed to make law. That is not its responsibility. But the Supreme Court has been making law, recognizing that the business fiction called a corporation has actual constitutional rights since 1819. And I don't have time to get into hardly any of the details. I'm just going to give you kind of an overview of what that means. Corporations now have First Amendment free speech rights. They won them in the 1930s. A lot of people think they won this in the Citizens United decision 5 years ago, but that's actually not true. In the 1930s, the Supreme Court granted corporate constitutional rights to the business corporation, and they did it in a newspaper case. It was a tax dispute of a newspaper with its government, with its local government. And once they won First Amendment free speech rights, the corporate lawyers started trying to figure out how to expand and expand and expand what is speech by a corporation. And it was all about definitions. So the more you could get the Supreme Court to define as speech, the business corporation could claim rights around that speech. So, for example, in 1976, the Supreme Court, in a case Buckley versus Valeo, V-A-L-E-O, decided that it was discriminatory to say that a corporation, actually they said a person, I'll just keep this simple. They said you can't discriminate about how much money a corporation can contribute to influence the outcome of an election, right? You can't limit how much money a corporation can give because that would violate its right to speak as a corporate person. Believe it or not, that's what the Supreme Court said in 1976. The activist community calls this the money equals speech decision. Right? That their money it actually equals, according to the Supreme Court, their right to speak under the First Amendment. So the right to speak got expanded, and the right to speak increasingly became the right to not speak. The corporate lawyers argued, well, since we have the right to speak, that means we have the right to not speak. Clearly, Judge. Right? Isn't it obvious? That's a subordinate right. So the right to not speak has been used in battles over labeling laws. The government wants nutrition labeling, or it wants country of origin labeling on a product. Where is the product from? Or the government wants, it's a chemical pesticide. It wants ingredients listed. What's in it, right? You have to tell us what's in the product. Tobacco labeling. So there have been big battles with corporations now for many decades around corporations claiming the right to not speak. Corporate speech also gives corporations lobbying rights, right? That's a corporate speech right. And on and on. So that's a little tidbit about corporate First Amendment free speech rights. Corporations have won property rights. A long time ago, they won property rights. Now, when we think of property in the material world, we think of back, a century ago anyway, property was the farm, right? The horses, right? That was your property. The property that corporate lawyers are much more interested in is what's called intangible property. Well, intangible property is ideas, right? Inventions, trademarks, patents, copyrights, right? And intangible property rights, that's the real juicy stuff for corporate lawyers. So over the latter half of the 20th century, corporate lawyers have won decision after decision that when you put them all together, ends up being the following, that corporate boards of directors now have unhindered legal authority to pretty much make all key economic decisions that affect all of us in the United States. They get to make, and the government can't interfere, and the public can't interfere, and the unions can't interfere. This is contractually settled, supposedly, that corporate boards of directors can decide what products are going to be produced, and how they're going to be produced, and where they're going to be produced, and what kind of byproducts or toxic side products are generated. That's all corporate decision making. We have no authority over any of that. And then once the profits start pouring in, what are we going to do with all those profits? Are we going to reinvest those profits back in the community? Are we going to give discounts to our customers? Are we going to give the CEO 1,000 times what the lowest paid employee makes as their annual income? Corporate constitutional rights. That corporations have won complete 100% decision-making authority over how work is organized, what's produced, and what happens with and how they invest their profits. Right? As a corporate constitutional right, that's an intangible property right of a corporate person. That's a lot of power. Right? A board of directors, we didn't elect the boards of directors of corporations, so that's all beyond the people's authority. Corporations have won privacy rights and protections against search and seizure, which has stopped them starting, I believe, in the 1970s, stops the fire department and the OSHA inspectors from doing surprise inspections in a factory or in a warehouse when they've heard that there are safety violations, health and safety violations have been reported. They're not allowed to do a surprise inspection in most cases because that would violate the corporation's right of privacy. Right? Corporations have right to a jury trial in many cases now. Recently, a couple of years ago, there's another really big expansion of corporate rights, which is a really good reminder that this is not a historical story, this is a current story that just keeps building. A couple of years ago, a big box chain store won through the Supreme Court a new corporate constitutional right. Anybody know what I'm talking about? To add to the list. Hobby Lobby Corporation. It was a couple who privately owned this giant chain store company, and they argued that they didn't want to give reproductive health care under Obamacare. They shouldn't have to give that care under Obamacare to their female employees. And they argued that that didn't violate their rights as the owners, it violated the corporation's rights, the it. They actually argued that the corporate it, the Hobby Lobby it, should have recognized religious freedom, right of religious freedom, as an it. Right? They weren't arguing as people. They already have, let's not forget, directors already have Bill of Rights protections. They're human beings, right? So I'm not talking about the people hiding behind the it. I'm talking about the it. Okay? Now think about it. This thing exists in the material world, right? I can pound on it. I can take a photograph of it. It's real. If I told you that we were going to pass a law to grant First Amendment rights, property rights, contract rights, privacy rights to this podium, many of you actually are laughing at me. Okay? It's ridiculous. It's silly. Well, this is even sillier. This is rights for things that don't even exist in the material world. Okay, that's an absurdity. But that's where we're at. 197 years later, we have the Supreme Court making law, which is not allowed in the separation of powers, activist courts, as many people call it. 197 years and counting, the U.S. Supreme Court has been granting one new constitutional right to corporations after another. So those are three structures of law in a nutshell. Let me check the time. I'm going to go about another 5 minutes, and then I'm going to open it up to conversation. You got to... Yeah, go for it.
Yeah, go for it. The actual fact that the Supreme Court and the court system is making laws, isn't that fraud, and can't that be reversed?
If we could figure out how to structurally do that, yeah, they shouldn't be allowed to do that. The courts don't make laws. Yeah, not legitimately.
The question has to do with corporate rights, but where are the papers that say what individuals' rights are?
In what? In the corporate decisions that the court is making? I'm not understanding.
Any paper or document says that individuals have rights.
I'm sorry, I'm talking about specific decisions that the Supreme Court has made that grant rights to corporations explicitly. They don't include people. These are decisions about corporate constitutional rights that I'm talking about.
Do humans have to get them in order to have them?
Do humans have to get?
Do they have to become a corporation to get these rights?
That there is a movement afoot that says that we already are corporations, and that's not a movement that I'm associated with, so I'm not going to speak to that. I'm talking about our specific movement. If that's what you're getting at, I'm not sure. Yeah.
What about right to privacy, for example, for individuals? How come we're getting searched and seized?
It's a very good question.
But the corporations aren't, and NSA and all that.
Do you want to repeat the question?
Is it that, like right to privacy, search and seizure, our rights are being violated around privacy and search and seizure, like the NSA, Homeland Security. Why are we having our rights violated, but corporations have? Because we're not organized, I guess. We are not standing up as a collectivity, as the people, right? Not as consumers, who vote with our dollars, like not as individuals who are just pissing mad, but as a body of people saying, we the people, this is not acceptable to us. We keep electing, as you may notice, people who violate our rights from both of the mainstream parties in massive numbers. We're constantly elected people who don't actually, they're not here to serve us. They're here to serve corporations.
But could it also have to do, I guess, with the organizing part, with intimidation? Because we're not organized, then a corporation may say, okay, we're going to react to your ruling or something like that.
That a corporation...
If they got searched, for example.
Sure.
Then the corporation may say, give some legal backlash or something like that. And we're not organized.
We're not organized, and the wealth is mostly in their hands at this point. And it's our money that's in their hands, right? That's why they're wealthy. It comes from us. So let me explain to you, let me just get this last piece of the story done and we can open up the conversation. So the farmers in Wells Township heard this explanation from the CELDF attorneys back in 1999. After 3 years of the CELDF attorneys working within this, what I now understand and describe as the conventional framework, regulatory framework of lawmaking, right? But that's actually, it turns out, this regulatory framework, it turns out is exactly where the corporate leaders want us as activists. It's exactly where our state and federal leaders want us when we're concerned citizens. Because it turns out that the entire regulatory framework of law, if you go back in history, starts in the 1880s when the Attorney General of the United States government meets privately with the heads of the railroad industries, which are the first giant business corporations in the U.S., late 1800s, the railroad companies. Southern Pacific Railroad is the first truly giant corporation in the United States. And the railroad industries in the 1870s and 80s were under enormous pressure from the public because up until that time, and we can talk about this later in the workshop if you want me to, up until that time, corporations were held subordinate from the first century in the United States. State legislatures wrote corporate charters uniquely one at a time. Investors would come to the state legislature and ask for the privilege of incorporating, and the legislature would incorporate that business. It was and actually still is, believe it or not, a business corporation is a state creation, right? You can't actually incorporate until you get the state to say okay and agree, right? There's still a process. So, and out of that first 100 years, corporate charters written for these companies were filled with requirements and prohibitions. Legislatures revoked corporate charters all the time when the corporate board of directors violated the law or caused significant harm. The charters very clearly said that all corporations shall serve one specific social need and cause no harm. That was the language in the charters that came out of the American Revolution for the entire first century in the United States. And by the time we get to the Industrial Revolution, we're entering into a period where we're going from craft-based manufacturing, if you could even call it manufacturing, production, to assembly line production, right? At the start of the as the Industrial Revolution is picking up speed in the second half of the 1800s. And so corporate leaders were saying, wait a minute, and cause no harm. We've got increasing numbers of the public outraged at the harm being created by a new kind of business of manufacturing, mass manufacturing corporation. And so the railroads and the Attorney General huddled together privately in the 1880s to come up with a way to shift from prohibiting harm, which had been the cultural and legal norm for the first century, to regulating harm. That was a massive culture shift moment in the United States. And the way they did it was they birthed a new kind of law called regulatory law. And regulatory law is very deceptive. Let me quote from an article called Sheep and Wolf's Clothing that's all about the birth of the regulatory agencies. The first regulatory agency was called the ICC, the Interstate Commerce Commission. This is what our Attorney General created. He said it was, quote, to be a sort of barrier between the railroad corporations and the people. A barrier. Said that Charles Adams, president of the Union Pacific Railroad, what is needed to solve the railroad's problem, quote, is something having a good sound but quite harmless, which will impress the popular mind with the idea that a great deal is being done when in reality very little is intended to be done, unquote. So if you've ever been to a regulatory hearing, that might ring familiar to you. Right? That the regulatory arena of law was set up to regulate citizen involvement in government. More than that's its primary purpose. I have a colleague who says the primary purpose of environmental regulations is to regulate environmentalists. And it does its job very well, right? We are kind of the bewildered herds. We're told that if we have a concern about, let's say, the Bakken pipeline, that we go to the state hearing in Boone, and we get to speak for 2 minutes. I was there, I watched, right? And that's it. That's your authority, right? That's the regulation of citizen interaction with what should be our authority over a decision-making process. We are now regulated into a black hole, right? So the farmers understood this after the Seldoff attorneys explained this crazy history to them, and they said, because I want to get through this story and be into more open conversation, they said, so you're telling us that we can't legally pass a law that bans factory farms in our township? And the Seldoff attorney says, that's right. You can't do it legally, but you could do it. We could draft you an ordinance, a local law, that bans factory farms in your township. And you could pass it, but yes, that law would be illegal because it would violate state preemption, Dillon's rule, and corporate constitutional rights. Now, if that doesn't matter to you, right, if you want to pass a law as a direct challenge to these structures of law that really are unjust, and if you think about it, constitutionally illegitimate, right? Because they all put us, the people, in a subordinate role under state and federal government, which is not where we are constitutionally, right? You could do that. And they said, please do. And so Seldoff drafted an ordinance for them in 1999. The township supervisors passed it unanimously in 1999. And it banned factory farms in Wells Township. And what happened next is really amazing. The large corporation that had an application in with the state, rather than sue, it pulled its application and it was gone. And very quickly word spread, and there were lots of other townships in Pennsylvania that also had applications for factory hog farms from the same corporation that was expanding from the Deep South into Pennsylvania. And over the next year or so, 20 mostly conservative townships in rural Pennsylvania, farm communities, passed this anti-corporate. It was simply called the Anti-Corporate Farming Ordinance. And all it did was ban, here's the full summation of what it did. The Anti-Corporate Farming Ordinance did two things. It prohibited non-family owned corporations from engaging in farming or owning farmland. And in the ordinance, in the law, was a definition for a family-owned corporation. which the township themselves crafted as a legal definition to have a very, very strict meaning for what they meant by family-owned corporation. It was something like 90 or 95% of all of the employees had to be part of that actual family, blood family. So this spread like wildfire into 20 other communities very quickly. 80 communities across rural Pennsylvania were watching what happened, and they passed in the next few years a ban on corporations dumping urban sewage sludge on farmland. 2 communities in Maine, Shapley is one, I'm forgetting the name of the other, were watching what was happening in rural Pennsylvania. They passed bans on water bottling corporations sucking up groundwater for corporate profit for sale. And in every one of those cases, certainly in the 2 main cases, there were applications on the ground. They pulled their applications and left. No lawsuit. 4 or 5 years ago, in Pittsburgh, the first major city to get involved in the community rights effort, the city of Pittsburgh, believe it or not, had major fracking applications on the table within the city. Fracking applications. The city council itself went to CELDF and said, we're following what you guys are doing. Could you pass an ordinance for us can you write an ordinance for us that bans fracking within Pittsburgh? Sure. And it was very quick turnaround. From the first conversation to the passage of the law was about 4 months. It was very urgent for the city council. And they passed it unanimously, the Pittsburgh City Council, unanimously. But they also did something else. Starting with the Pittsburgh City Council about 4 or 5 years ago, the ordinances didn't just contain a basic corporate ban anymore. Now they were about the right of the people to have a basic level of protection. So there was a more comprehensive framework for the ordinance. So starting with Pittsburgh, the ordinances are about rights and about a prohibition. The Pittsburgh ordinance is called the Right to Water and Self-Government Ordinance. And the relationship is, we're going to establish a new set of rights that we, the people, are going to figure out in our local community. These are rights that matter to us. Right to water, right to clean air, right to healthy environment, right to whatever, right? You decide, the community decides. And then we're going to ban a particular corporate activity, in this case fracking, because we're going to have to do that to protect the rights we've just established for ourselves. Right? So we're establishing a right to water ordinance. We're going to ban fracking because now it would be a violation of our right to water in Pittsburgh. That's the link.
Why did the corporations back down so easily?
It's a really good question. Up until this point, so jumping ahead a little bit, there are 200 communities now in 9 states that have passed community rights laws. And only 5% have ever been legally challenged since 1999. 5%. And we can only guess, I can give you the guess from our movement, of course, because the corporate lawyers aren't telling us why they're not suing in most cases. We won't know that probably for a while. The 2 best guesses are that so far, when it's only 200 communities in 9 states, these big businesses can find somewhere else to go where there isn't a community that's mobilized to say no through this very particular legal framework.
We haven't really gotten up against the confrontation.
Right, we're just starting to get legal confrontations in the last few years. And the other reason that we believe is that our ordinances are drafted in such a way to force a whole different kind of lawsuit. Right? There are still communities all over the United States that think that you can ban a corporate activity through zoning and regulations. And they do it all the time. Right? I'm working with a group in Winona, Minnesota, and I just got an email from them yesterday. And the city council and the county supervisors have just decided that in principle, they're prepared to pass a zoning ban on frac sand mining within the county, which is kind of a brave step, right? To pass something where they could be sued, right? Counties and cities usually don't go even that far. Clearly, Wells Township and these other communities did. But the problem is that if you pass a frac sand mining ban in Winona County, Minnesota, and you do it through zoning isn't about banning. Just like regulating isn't about banning. Zoning, under conventional law, is about where, not if. right, is you're going to set up zones on the map as a local government and decide where certain things are allowed. Not they're not allowed anywhere in the county. That's actually not what zoning is. But lots of governments think, oh, this is really clever. We can get around these things and we'll just use zoning to make it impossible for them to put it anywhere. And what happens is they get sued, almost always, and the judge says, yeah, you're right. You can't use zoning to ban. That's not what zoning's for. And the law is thrown out. That's what will probably happen. But when you pass, if they didn't use zoning, if instead in Winona County, Minnesota, as I've been pushing them to do now for a year, if they could convince their elected officials locally to pass a community rights ban on frac sand mining, then you're in a whole different kind of legal battle, which is actually a lot more fun for the public to watch this unfold, because now the corporate lawyers have to argue that the corporate it has more constitutionally protected rights than the residents of the county. Right? That has to be their central argument. They have to peel away all of its rights-based language. And that's the other reason we believe that most of these have never been challenged, is a corporate attorney can challenge a zoning ban in their sleep. Right? They don't even have to write the legal draft. They just pull it from the last time. Right? A corporate attorney cannot challenge a community rights ban in their sleep. Right? This is our lawmaking. In other words, imagine, if you will, if you are willing to suspend your disbelief and believe me that the whole regulatory arena of law is actually corporate turf, which we believe it is, right? The government, the state and federal government, and the corporate leaders want us there, in their turf, in the regulatory system of law. Because who wrote regulatory law? If you look at regulatory law, it's written by the industries that are regulated. Okay? Who are the directors of regulatory agencies? They're in revolving door, the leaders of the industries that are regulated. Okay? We're in corporate turf. So if you're writing a law, or if you're making a plea to an agency on corporate turf, of course you're going to lose. Right? But what if you create what we call paradigm shifting law that's rights-based, where we're arguing that our rights are paramount, as proven, as guaranteed in the state and federal constitutions, and that historically corporations, in these historic charters, corporations were given privileges, not rights, because they don't exist in the material world. There was a cultural understanding you don't give an it rights. You give them privileges written into their charter. Right? So imagine if you're passing laws where the corporate attorneys now have to step out of the playing field of law that they're so familiar with and into our turf that's controlled by we the people. Right? Now we're in a whole different political and legal battle. And so I'll end my presentation there, that this movement has basically become a movement of 200 communities in 9 states so far, and 6 state community rights networks so far, that are starting to build power up. We're passing local laws that challenge illegitimate state and federal structures of law, that violate our constitutional rights to protect our community's health and welfare. And once we do that, we push those rights into local law. And to start defending them, we then have to push rights further up into the legal system. So then we form state networks of community rights locals, and they start driving community local rights into state legal structures. Because the state still says you can't do this at the local level. So we need to change state laws to make what we're doing fully legal. And then we push further up into the federal laws and the federal constitution ultimately. So the long-term vision is that we've rewritten our state and federal constitutional laws so that local self-governing authority is actually at the top. And because we actually believe that if you aren't able to practice democracy where you live, you can't claim you live in a democratic society. Right? So that's the vision, is that actually right now we have federal trumps state, trumps local. And what we're trying to do is shift it So it's local trumps state trumps federal, but with one very specific limit, and this is an area where the left and the right have a little bit of creative tension, is that we in the community rights movement believe that it is an absolutely appropriate role for all levels of government to protect rights, and that it's illegitimate for government to take rights away from any group of people. And so we believe that the federal government should have the authority to set the floor for rights and protections, but not set the ceiling. That they should have the legitimate authority to say, this is the minimum rights that all people in the country are going to have. If the state wants to raise those rights, they have that power. If the local wants to raise those rights, they have that power. So we do actually see appropriate use for the state and federal government to set a minimum standard for environmental protection and rights. So that's kind of a basic overview of our work.
Of the cases that have gone to court where they haven't withdrawn their permits,
yes.
Do we have any? What's the update on the outcome?
In the 5% where there was a legal challenge.
Yes.
So we have no actual settlements yet of the 5%. What we mostly have is town councils and a few counties that got scared when they were sued, and they took the law off the books immediately for fear of a lawsuit, which for us misses the point, right? We're actually trying to challenge these unjust laws. And so there are various ways to do that, but our movement has attorneys that provide legal support to a local government or local community to defend the law once there is a legal challenge. Because to us, part of writing these laws is to force the legal challenge into our turf and to play out that legal battle in the courts and have the public really start to understand that corporations do have more constitutional rights than we do, and that that's fundamentally unacceptable in a society that's trying to be democratic, right? And so people get actively involved rather than just getting more depressed. In these kinds of lawsuits, the public tends to get more actively involved in defending their local government, in its right to protect the public.
The problem is the bonds. The problem is the bond lean against the bonds, and the city goes bankrupt or the township.
That is usually the fear.
And
that is the fear.
So it's about money.
It very much is about money. And so what I find so fascinating culturally in terms of this work is much more, I should say, about culture shift than it is about lawmaking. I don't know if you've noticed that yet, as I've described it. It's about a people reorienting who they are in relation to their institutions, be they government or corporate business institutions. So what has happened in the 200 communities that have already passed these is that those local governments got to a place in their heads, in a cultural sense in their communities, that they feared the corporate harm that was going to come more than they feared being sued. That's a huge culture shift in our litigious, litigation-terrorized local governments, right? We're terrified of being sued in our local governments, right? So, and we have to stop being. We have to start saying, this is too important. So if we're sued, we're sued. That's just the way it is, because we got to get our power back as we the people.
So, as a devil's advocate point or question, you were talking about the ideal that the government would set the floor for rights, and then the state or county or city could do the right.
Raise those rights.
Okay, devil's advocate. I was a conscientious objector in the Vietnam era, and what if a local or county or state said, "Oh, our right is not to have to serve in the military." Right? How can you argue that, or is that a valid extension?
You're saying the county would say no one who lives in our county has to serve? Is that what you're proposing?
Because we have a right for believing not in fighting.
That's a really interesting example. I've never heard that as an example. I don't know why they couldn't do it. Again, it has to come out of a majority sense of the culture, right? Like if the city council or the county passed that, and the population in the county thought that was ridiculous, they'd throw them out of office and they would change the law with their new electeds.
But what I'm trying to say
But if they supported it, what is wrong with that?
Well, what I'm trying to say is that this would be the argument that they, whoever they is, would make to say it's absurd to be able to do that, because then cities or counties could make all sorts of claims that would be unarguable, that would make the society in general inoperable.
Well, and I think we need to look back at what our first Constitution said, which said that local and state government holds ultimate decision-making authority, not the feds, right? We went from decentralized decision-making authority in the Articles of Confederation and Perpetual Union, our first Constitution. And I don't know, this is my analysis is there was a political coup a decade later by Madison and Washington and others, and we ended up with a strong federal, weak state constitution. So yes, they are going to make that argument, but the state and federal government are also legal fictions, right? So the question is, who are we and what do we want, right? And if what we want is decision-making authority at that scale, given what our authority is constitutionally, why wouldn't we do that? I mean, you've got major food processing companies arguing that that local governments, county governments, should not have the right to ban GMO agriculture, right? This is happening all the time, right? In my state of Oregon, our state legislature, which is overwhelmingly Democrat-controlled, last year passed a law that bans counties from prohibiting GMO agriculture. Democrats did that in my county, right? It doesn't matter. We have now two parties that are completely bought by giant corporations, right? There's the story in many people's heads is these are what Republicans do, but no, this is what everybody. Both of our parties are now fully corporatized, right? Now, why can't a people who actually live on a piece of landscape in a county have the authority to say we don't want GMO agriculture here? Okay, so it doesn't meet the needs of global Monsanto or whatever commerce. But again, that's a legal fiction, right? So does the public have the right or not? Hawaii?
In Monsanto, the test farms.
Yeah.
That's the perfect example.
Hawaii. He's saying Hawaii. Hawaii is in big battles with GMO. Is in a big GMO battle at this point.
Level against the state.
Mm-hmm. Yeah. In Oregon we have a number of Jackson County, Oregon. I live in Portland, Oregon. We had a conventional ban, i.e., not a community rights ban, but a regulatory or zoning ban. I forget what it was, where they made it illegal to do GMO agriculture anywhere in Jackson County, and the state Monsanto put massive pressure on our state legislators, Democrats and Republicans, who very quickly banned this happening any further, but there was enough pushback that they grandfathered in Jackson County's law. So we have one county that is legally banning GMO agriculture, so then Syngenta sued the county, and they just lost. The county won, so far it holds. But these are the battles of our time, right? We have an overwhelming amount of corporate power in the United States, right? We have, how many people are following the Iowa Utilities Board in this state? Are you paying attention to the back-end thing? I mean, it's coming right through your county, right? You're on the pipeline route. The Boone County Board of Supervisors passed a resolution a few months ago saying over 3-0, we don't want it here. Now, a resolution is non-binding. It's symbolic, right? They're not going to be afraid of being sued. It has no power. I was in Boone County over the last week and a half, met with some of the supervisors, even got an op-ed published in the Des Moines Register about this, you might have seen, a week and a half ago, saying, regardless of what the Iowa Utility Board decides, and we're all assuming they're going to approve it, because they are a unaccountable, governor-chosen regulatory agency of 3 political appointees, that it seems I'd be stunned if they didn't approve this. And why can't the people of Boone County say no?
Well, it should be a snake of all of those counties.
That would be great. But they're the only county that's been brave enough to even pass a resolution against it so far. Right? We'd love to see your county supervisors do that.
Yeah.
Are there any local elected officials in the room? That's too bad. So in about 5 minutes, we're gonna take a short break. I want to do a couple things real quick before we do. We're gonna pass. Where are our? Yeah. We're gonna pass a few baskets through the room. If you want to make a contribution towards some really important work that's going to be happening here. If you already made a contribution, considering making another. If you haven't, please throw some money into the baskets. I do this work full time, and they're paying me to be here. There is a local community rights group. Tom, does it have a formal name, your group?
JCRN, which means the Jefferson County Community Rights Network.
Community Rights Network. The Jefferson County Community Rights Network, which, by the way, has a website, which is jcrn.org. The Jefferson County Community Rights Network has an active ordinance writing campaign. They have a draft ordinance that is not quite in its public form yet, that is a no more CAFOs ban, countywide, that they're going to start doing house parties in this county or have already recently. They're interested in people getting involved with them. So as this thing goes around, if you're interested in finding out does the form have a place where you can...
put the category you're interested in.
So if you're interested in finding out more about the CAFO ban community rights ordinance, you want to get involved, say something, write house parties or write CAFO or write something, so they'll know you're interested in finding out more.
So this is the reason why we're having you sign something else other than what you signed when you came in, is because for this we want to know what you're interested in. Because essentially what we want to have is, let's say we have 5 or 6 different groups: water, food, backings, CAFOs. What you're interested in, and we'll form small groups of people who are interested in those things, and we'll get several groups going on different projects. So just write down what you're interested in.
So we had a couple other volunteers who are going to take baskets. The baskets are all here. If you could come and grab them right now. Yeah.
I have a question regarding what Clyde just said.
Yes.
This is a GMO county in a big way.
Yes.
And from the presentation that John Fagan gave on Sunday night about GMOs, he made the point very logically that GMOs are like the linchpin for all these other problems, and he gave the whole logic for that. But it doesn't seem to be a lot of point to try to open the GMO here because our elected government wouldn't pass it because it's a farming community. So should we just not bother?
Well, it's not a GMO ordinance. It's a no more CAFOs ordinance, the one that they're starting to circulate.
Okay.
But it's totally up to each town or city or township or county what kind of community rights ordinance you might want. For example, up in...
One second.
Yes.
If they write a check, who do you want the check to go?
To my name is fine.
Okay.
Yeah.
So Paul Cienfuegos, which is written right up there.
Yes. Okay, what was I just saying? Yeah, it's, there are lots of counties that would never think of passing a no more CAFOs ordinance. They're okay with CAFOs. Let's say, that's fine. This is a local control movement. What are we comfortable with in our local community? There's a woman here from 100 Grannies for a Livable Future. You want to stand up for a sec? This is Deborah D. And she's here from the Iowa City Community Rights Group. And they're working on a draft community rights ordinance that would ban any pesticide spraying on public lands anywhere in the county. That's their focus, right? That's an issue that already is hot in their county. In Winnebago County, Iowa, a community rights ordinance has already been written that they're trying to get passed. This is Decorah's county in the northeast corner of your state. For 2 years, they've had an active community rights group. that would ban frac sand mining countywide. Right? So what is the issue in your local? It's not like you're being forced to pass something you're not interested in passing. I clearly didn't.
In theory, I wanted to be in a non-GMO group. But I feel like, what's the point of trying?
Yes.
Isn't that correct?
Yeah, that's I think ultimately correct, unless you want to do the long-term work of deep public education so that both the public and farmers start to get it that, in my opinion, is a proven fact at this point that GMOs are dangerous. Now, that's not what the official story still is in government. But, there are nation states all over the world that have banned GMO agriculture. They didn't do it because it was a goofy idea.
But the point is that right now we're trying to work on something that can work more quickly, right?
Yeah, most groups don't want to do something that can't possibly get a majority of support. Yeah. And you have to work in the reality of your local cultural norms. Yes, in the back.
So that raises the broader question about how these corporations utilizing different techniques. Like one is I've heard of called the Delphi technique, which has been used by Agenda 21, which is now being called Agenda 2030 because people started to catch on. But to be able to take communities and to take groups and fracture them and get them to argue amongst themselves while the corporations, including the government corporations, are allowed to proceed, with their agenda. So I apologize that I didn't arrive until about an hour and 15 minutes after you started your talk. But have you developed any strategies that would allow individuals and groups and communities to anticipate that one of the main things that the corporations are going to do is to try to get the communities to argue amongst themselves so that they won't be able to move forward with a unified course of action?
That's a wonderful question, and I don't think the corporations really at this point have to do much of anything. I think that Democrats already hate, despise, distrust Republicans, and Republicans already hate, distrust, despise Democrats, and the Greens think all the parties are crazy, and the Libertarians think all those other parties are crazy. Okay, and so there is dividing, let me just finish, there is divide and conquer that's been effective and working just great for the entire history of the United States, whites versus people of color, etc., etc., right? So we're already divided, and in this county, I've been pushing hard to get the libertarian elements and the progressive elements at a minimum in this county to get past their distrust. And we had a meeting today, and we're having a meeting tomorrow. And if some of the people who are there want to speak to that, that would be great. But yes, the fear of working with the other is overwhelming in this country. Yeah. Absolutely. Workers versus environmentalists. There's all of these constructions, these propaganda-based constructions of reality that we have to work against.
So it's a pre-existing...
It's pre-existing. It's not a new phenomenon.
So what have you found works to get people to come together?
Well, when progressives, I do a lot of teaching in the Northwest where I live, mostly in very progressive or politically green-oriented groups. And what I say to them is that the vast majority of the 200 communities in 9 states that have passed these are conservative communities. And they're shocked. Because to them, conservatives have green horns. I mean, it's just pathetic. It is pathetic. And then I go into conservative communities, and I have to say honestly, conservatives who are involved in this work seem much more hungry to work with progressives than progressives seem hungry to work with conservatives. Conservatives seem more culturally ready to go, okay, let's give this a try. Whereas the Democrats and the progressives that I mostly work with seem like they just keep throwing up another cultural barrier because it's too scary. So there's some cultural work to do here. But Clyde, wherever he is,
I'll just say this.
Is a libertarian, and we've had 2 hours of conversations in the last few days, and we hardly disagree on anything that matters.
We all know that love is unifying, and what I will say about these meetings...
Speak into this if you want the recording to pick you up properly.
Is that love is unifying, and what I've been feeling at these meetings is a lot of love. And a unifying feeling that's really, really, really powerful. Ed and I met with Fred and Tom for lunch a couple weeks ago. That was the first time the 4 of us got together. And, first of all, we agreed on almost everything. A lot of these labels and these divisions are in our head. They don't even exist when we sit down and actually start talking. Even some of the things that Paul and I have been spending hours talking about, different issues that we thought might be contentious, but when we really looked at them, there wasn't that much difference. Between Paul, who I consider a progressive, and me, who's a libertarian. Really, it's just a matter of framing on a lot of these issues. So what we're seeing is a unifying taking place right here. I'm feeling tremendous about it. And I think when love comes in, fear goes out. It's like light comes in, dark goes out, love comes in, it's unifying, and the fear is going out. I think what's happening here is the fear is leaving. You guys agree with me, Fred, Tom? You feel this? That's what I feel. And anyway, yeah.
Definitely a nice process is beginning.
A nice process is beginning. And we know it's a process. We're not expecting miracles overnight. But just what's happened so far, to me, is extremely significant.
One thing that's dividing is that there are synonyms that are being used by left and right as different.
Yeah.
But they're not different at all. For example, the right uses words liberty and freedom. The left uses rights. They're synonyms.
Injustice, yeah.
Injustice, yeah.
Right.
And the same thing.
Massive.
In the foyer, I've been working on the theoretical structure of this, which is to complement the love feeling, the intellectual work on this. And there's a little table set up in the foyer. If you want to stop by, I have a handout.
Yeah.
It's an amazing handout. Check it out.
Yeah, definitely check it out.
I want to just say one last
thing.
So before we take a 10-minute break, so after we come back, if you have time...
Tom's going to talk.
Oh, that's right. Thank you. And Tom's going to say a word before we break also. But I really want you to look at the timeline and check out the books, and I'm going to direct you to a handful of real specific ones there's a lot of books there. And I want to urge you to buy one of these or more of these and keep them in your community and start sharing them around. Be the Change is the first book. It's out of print, so here it is as a photocopy. That's how I'm selling it, small book, which is the birth of the community rights movement in rural conservative New Hampshire and Pennsylvania. Gaveling Down the Rabble, which is amazing stories of how corporations won the Constitution, written by a terrific storyteller. So it's not dry and boring. It's actually stories. On community civil disobedience in the name of sustainability. This is a great primer about the community rights movement. If you're interested in the actual legal framework that we use to defend our ordinances, this is the actual 30-page legal brief that our side is using currently. It's a current court case in Grant Township, Pennsylvania, where a utility company is suing Grant Township for its fracking ban. And this is the legal brief in response, and it lays out the legal arguments incredibly beautifully in a way that anybody with a high school education can really get. And lastly, if you're a watcher more than a reader, Reclaiming Democracy is a 2-hour interviews and lectures about community rights by some of our leading speakers. So I really urge you to make these especially these 5, make the piles shrink at break. And Tom, where are you? So Tom's going to have a brief comment, and then we'll take a break. And when we come back, we're going to go over the ordinance that I handed you. So don't leave yet, right? And we're going to talk through what a community rights ordinance actually looks like and how it works.